Good morning. My name is Haley Box, and I'm an attorney with the Legal Aid Center of Southern Nevada, specifically in the Legal Service Fund program. I'm going to be talking to you today about criminal record sealing. So this is going to be a tutorial on how to get your criminal records sealed in Clark County here in Nevada. Okay, so I'm going to tell you a little bit about the Legal Service Fund program and some of the services that we provide to Culinary and Bartenders Union members. So the Legal Service Fund program is a partnership between the Culinary and Bartenders Union, so that's 226 and 165, and then Legal Aid Center of Southern Nevada, which is where I work. It was created to provide members with, legal information, consultations, and also sometimes full representation, depending upon their legal issue. So some of the services that we provide, we have tip compliance, we have immigration services, bankruptcy consultations, we help with consumer issues like garnishments, debt collection, anything to do with money. We also provide family law information. We do not provide extended services or full representation for family law, but if you have questions or you need forms for divorce, custody, paternity, any of those types of issues, you can call us and we can direct you to the resources and forms that you may need. We also do tenants' rights and eviction defense. And then also what we're talking about today, which is criminal record sealing. We also do estate planning, which is a very popular part of our services, where you can get a will drafted, you can get powers of attorney drafted, you can get deeds upon death, healthcare directives, and other such things. We also assist with unemployment overpayments that have to do with issues that you had while you were unemployed, if you were unemployed during the COVID-19 pandemic. So we don't do unemployment, like new unemployment issues, but if you do have overpayments from back during the pandemic, then we do assist with those. So all of our services are free to qualifying members. All you have to do is call our office and we will run a verification to see if you meet the qualifications. And so you have to have worked at least 80 hours per month on average for the last 6 months, and you have to work for a contributing property, which is a very large amount of the properties that are, on the strip or in downtown or in other places. So you can call us at 702-386-1550, or you can email us at lsf@lacsn.org. Okay, so I'm going to talk to you today about criminal record sealing here in Nevada. Now, every state has a different process. This is the process for Nevada and specifically Clark County, but all of Nevada is bound by the statutes, the criminal record sealing statutes. So it should work fairly similarly across the state, but there's going to be a few differences here and there. But we mostly work in Clark County. So the process, it may take up to 6 to 9 months. It has been taking a little bit longer due to some of the wait times. But we are doing some new things to hopefully shorten that amount of time. But right now, if we're seeking stipulations in some of these cases, it can take over a year. So it really just depends upon, your criminal history and like how many charges you have, like what court we have to file in, the requirements of that court, things like that really affect the length of time. Let's see here. So you have to meet certain requirements. The biggest thing you have to meet is the statutory wait times for each crime that is on your criminal history. So as you may as you may have thought, like the higher class of like misdemeanor or felony, the longer the wait times. There are certain charges that have an enhanced wait time, which makes the wait time longer. That would be like DUIs and domestic violence. So battery with domestic violence, those have a little bit longer wait times, but generally. And then there are also some types of cases that cannot be sealed. But the longest wait time for sealable is about 10 years. So, you're not going to be, if your charge is more than 10 years old and it is a sealable charge, then generally we're going to be able to seal it. And then the eligibility timeline begins at the close of your criminal case. So it's not when you're charged, it's when you've completed all of your requirements. So that would be, your probation, any jail time, paid any fines, gone to driving school, gone to DUI school, taking your anger management classes, whatever the requirements to close your case were. When you completed all of those, that's when the timeline starts to run for for the statutory wait time. So it's not, let's just say that you have a misdemeanor. It's not, most misdemeanors have a 1 year wait time. It's not 1 year from when you're charged. It's 1 year from when you paid your fine or completed a class that was required. So it's 1 year from the close of your case. Okay. So as you can see on this list, like there are different wait times for different types of charges. So, crimes against children, that's going to be not like neglect is sealable. Some things like that. Not all crimes against children are unsealable, but generally any type of like sexual offenses against children, child pornography, things like that, those are not sealable. If you have a felony DUI, that is also not sealable. Misdemeanor DUIs are sealable, but they do have a 7-year wait period. So category A crimes, those are, the more violent crimes, burglary, I think assault with a deadly weapon could, be in there. Those are a 10-year wait time. Category B, C, or D felony, those are more like theft, things like that. That's going to be a 5-year. Category E felony are the lower end felonies. Those are 2 years. The enhanceable misdemeanors are non-felony DUIs or non-felony domestic batteries. Those have a 7-year wait period. Most misdemeanors, gross misdemeanors, misdemeanor battery, harassment, stalking, violation of a protection order in a domestic violence case, those are a 2-year wait period, and then all other misdemeanors and traffic violations are a year. If your charges were dismissed, but they're still on your record, we can seal those immediately. And then the charges for like if the DA refused to prosecute, it's like once the statute of limitations is run on the case, most of the time that's like 2 or 3 years, or 8 years after the arrest, or if agreed by the parties. So if the DA signs off on it, it doesn't matter. Like if they're fine with the seal, it's fine. So that is that's kind of the full list of everything that has in the different statutory wait times for each type of crime. So we're going to talk about sealing your criminal record in phases. So the first phase is to gather information. So you're going to have to gather documentation needed to draft the petition to seal criminal records. In order to get the information, you have to have a driver's license, so a valid ID, either a driver's license or a passport. And then a person will request their criminal history report, which is what we call a CHR. So that is, you have to send off a form up to Carson City. You wait 6 to 8 weeks. It takes a while to get back, and then they will send you your criminal history report, which is basically everything that the Department of Public Safety of Nevada has on you. And then you're going to have to request your scope, which is the police department record. So we have to have a copy of both. We have to have a copy of the CHR and a copy of the scope. So wherever you were arrested, so if you have a charge in Henderson and you have a charge in North Las Vegas and you have a charge here in just in the city of Las Vegas, you would have to go to the Las Vegas Metro Police Department, the Henderson Police Department, and the North Las Vegas Police Department and get a scope from each. So wherever you were arrested, you have to go to that arresting organization to get a copy of your scope. And then potentially you have to get other essential information like judgment of convictions, like graduation from anger management, probation, discharge papers, things like that. It really just depends upon your case. A lot of that can be collected online, or you can go to the court and get copies. So as I said before, the CHR, to request the CHR, you have to remember the 3 F's. So form, fingerprints, and fee. So you're going to fill out the form, which is the DPS 006 form. You can find it online. It is pretty basic information. You fill it out, you sign it, and then you have to get your fingerprints done. They have to be taken by a fingerprint technician. You know, like Fingerprint Pros is who we go to. There are tons of like private fingerprinting agencies in this town. You can go pay the fee to get the fingerprint. They'll do your fingerprints for you. You know, and it's not going to be more than like $20, $30 to get your fingerprints done. And then you have to send the original like fingerprint sheet that they give you at the fingerprint place. And then you have to get a fee, which is a money order or certified check for the amount of $27. It can't be waived. You have to pay it. So you send the form, your fingerprints, and the money order or certified check to up to Carson City to the Department of Public Safety. And the certified check has to be made out to the Department of Public Safety. They don't accept like personal checks or cash. It has to be money order or a personal check. Money order or a certified check. So you'll mail the CHR request. The DPS form 006 has the address where you'll send it. It has it at the bottom, like with the address where you need to send everything. You'll staple together the form, the fingerprint, and the fee. You'll put them all in the envelope. This is the you'll mail the envelope to the Department of Public Safety. This address with the information is on that form, and then it takes 6 to 8 weeks to get back. So a lot of this process is a lot of waiting. So. And then to get the scope, you go to the arresting agency where you were arrested, and you have to get one from each of those police. So if you've only been arrested once or twice and it was by the same people, you just get one scope and it has all the things on it. But if you were arrested by multiple police departments, then you'll have to go to each one. And then on the left side of the slide here, it has the different requirements for each. So like the Metro Police Department, their fee is $10 and you need a valid photo ID. And then Henderson, there is no fee. You do need a valid ID, and then they're closed on Fridays. Boulder City, $1 per page. Like it really just depends upon the agency, and generally they accept cash. Some of them take cash, credit, or debit, but I would probably take cash with you, like $20-ish, just to be safe, and then and then make sure you take your valid photo ID. Oh, and also this is something that is kind of particular to the North Las Vegas Municipal Court. So if you have city charges in North Las Vegas, they're going to require you to get scopes from everyone. So you may have to go around and get, even if you were never arrested there. I don't know why they require this, but this is something that is kind of particular to them. But they require a North Las Vegas Police Department scope, a Las Vegas Metro, and a Henderson Police Department scope. I don't know why it's like that, but they make their own rules. So we just try to abide by it. Okay, so the next thing is you're going to get supporting documents. I talked about this earlier. So you may have to get a copy of like the judgment of conviction or your probation discharge papers if you were in jail and then you got, or if you were, you got probation instead of jail time, we'll need to see, what the date of the completion of your probation was, your parole discharge papers, if you were in jail, like when you were paroled, and then, or prison discharge paper, like whatever, anything that, any type of dates that will show when the quote unquote close of your case was, so that we can see whether you have met the statutory weight requirements for that charge. And so, again, most of this is filed in your case with the court, so it can be pulled either at the courthouse or online. Like, for example, I have like an account, so I can pull those for you. But if you're trying to do this yourself, you can go to the courthouse and they will give you copies of that stuff. So the next thing is the actual drafting of the petition. Once you receive the CHR and the scopes back, you'll start there. So you're going to organize all the information you have. You're going to, look at the charges that you have. You're going to look at when you completed everything. You're going to calculate the wait times to make sure that you've met all the wait times, because you can't seal if there is still an outstanding. Let's just say that you've got a misdemeanor 6 months ago. Well, it's not ready to seal. Well, it's still, the wait time is still pending, even though you have other things that are eligible for seal. Because you have that one misdemeanor that's not ready for seal, you can't seal anything. It's sort of an all or nothing type situation. And so you have to wait 6 more months for that last timeline to run, and then you can put everything into one petition and seal it. Once everything is eligible for seal, it all has to be, ready to be sealed. So the next step is to figure out, where you should file the petition. Okay, so when you're drafting the petition, you're going to make a charge list. So that includes the date of arrest, the arresting agency, the original charge, the case number, and the final outcome. So the final outcome, if there was a plea or anything like that, you need to put the final. So if it was let's see, if it was a, assault with a deadly weapon and it got pled down to just attempted, just regular assault, then you will put the actual regular assault. You'll say the original charge was assault with a deadly weapon, and then the final outcome was just assault or dismissed, and then, assault guilty or dismissed or denied or whatever, prosecution, whatever the final outcome was. If there are multiple dates for one charge, just put all the dates on there just to cover your bases. And you can see the charge list example. It has the arrest date, the arresting agency, which could be the Las Vegas Metro PD, the original charge, and then the case number, and then the final disposition. That's how you organize your petition. Once you have completed, making a list of your charges, you use the scope in the CHR to list all the charges. You can also go online and check the, for traffic violations and stuff, you can check the court websites to make sure you're not missing anything. So the next step is to mail everything to the district attorney. Now, this is not required. However, we have started filing these without sending them to the district attorney because the wait times are so long. We're not really sure why the wait times are so long, but it's upwards of 4 or 6 months now for getting things back from the district attorney. But honestly, it is easier because if the district attorney stipulates to the seal, even if it takes them a long time, when you file it in court, they usually just grant it with no hearing. There's usually no issues if the district attorney will just sign off saying that they agree to the seal. So it is even if it does take a while, it still is probably the most I guess the easiest path, because if the DA, if you file it in court without sending it to the DA and they object, you may have to go to court. You may have to, get in front of a judge and like argue and things like that. So, but, it really just depends upon like how quickly you need it done. So, this is how you prepare the mailing packet to the district attorney. If you're going to send it in, you have to send 2 copies of everything. Everything should be in blue ink. You make all these packets. You have a cover letter. There's these mailing instructions. This is where you would send everything. And then $2 in postage for each envelope. And then once you get everything sent off to the district attorney, you really just have to wait for it to come back. They'll either sign or oppose the forms. Most of the time, if it's done correctly, and everything is included, they're not going to oppose as long as the wait times have passed. It can take up to 4 to 6 months. Right now, it's taking a very long time. If they do not approve the petition, they'll send it back with a letter saying why they didn't and what the problems are. You can correct those issues and resubmit to the DA, or you can file it in the court. It's up to you. The resubmission process can take another 6 to 8 weeks. It just takes forever to come back from the DA. And so you don't have to submit everything to the DA. You can just file it in court, and then there's like a 30-day wait period. And if the DA does not object, then the court will presumptively seal, most of the time without a hearing. But if the DA does object, a hearing will be set. And some judges will set a hearing anyway. Like it just really, but most of the time, if the stipulations are signed, there is no hearing. But sometimes judges just like to set hearings to, they want to hear from the petitioner. So if you submit everything to the district attorney, and once you receive the documents back from the district attorney or the city attorney, if you only have municipal charges, you'll send it to the city attorney and not the DA. But most of the time, it needs to go to the DA. The next step is to prepare the filing packets. Okay. All right. So this is some of the special municipal court rules. So when you only have a municipal charge, which is like city charges, a lot of these are traffic tickets, smaller charges, things like that. You don't have to send that to the DA. You just send that straight to the city attorney of whatever city where you have the municipal charges. If you choose to file in district court, in that case includes a municipal charge, and they must submit the petition to the city attorney where they were charged before submitting to the district attorney. So this is a special court rule. So if you have, generally, if you have multiple charges across multiple jurisdictions, so let's say you have a Las Vegas Justice Court charge, and you have a City of Las Vegas municipal charge, and then you have a district court charge, we usually recommend that you file one petition in the district court because they have the ability to seal all charges. They have the jurisdiction. Now, if but the fee is higher. It's like $280, $70 something. And it's cheaper to file in Las Vegas Justice Court if you only have Justice Court, but the Justice Court doesn't have the ability to seal your municipal charges on top of it. So if you have multiple charges, it may be cheaper to just file one petition in the district court, which is usually what I do. But if you only have charges in one particular jurisdiction, then you can file in that jurisdiction. And but if you're going to file in the district court because you have multiple charges in multiple jurisdictions, then you have municipal charges, which is city charges. It has to go to the city attorney first, and then it will come. You send it to the city attorney, it'll come back, and then you'll send it to the DA, and then it'll come back, and then you can file it if the stipulations are signed. Now, you don't have to submit it to anybody, really, but the stipulations from the city attorney and the district attorney really do help ease the process and make it so you are probably not going to have to go to a hearing and go to court. Okay, so these are the different types of requirements for filing in the municipal courts over here on the right. Okay, so filing the petition, like I said before, if you have multiple charges in multiple jurisdictions, most of the time it's the most efficient and easiest just to file in the 8th Judicial District Court. That's one petition. It does cost a little bit more, but you only have to follow that one petition. You may choose to file in multiple jurisdictions. If you want to file just in the city court, you can, and also file one in the justice court. Or if you only have charges in one jurisdiction, you can file just in that jurisdiction. So it really just depends upon where your charges are. And these are the required documents. So you're going to have the cover sheet, the original order with the DA's signature, 4 copies of the order, original petition, original declaration, the CHR, the supporting documentation, the filing fee, and then payment for certified copies, which is $12. And that may be a little bit higher. You may have to call the court and ask. And then once the order is signed, you will, so generally what happens is, so 2 things can happen. You can either file the petition without sending it to the DA and the city attorney. If the 30 days pass and there are no objections by the district attorney or the city attorney, then the court will generally just sign off on the order and say that your records have been sealed. Or you can go through the process of sending it to the different agencies, like the city attorney and the district attorney, to get their signature saying that they agree to the seal. Then you can file it with the court, and then the court will just sign off on it again. If you file without sending it to the DA or the city attorney and the DA objects, a hearing will be set and you'll have to go to court. But that's only if they object. But once the order is signed, the order to seal is signed by the judge, you have to notify agencies. So you'll need to notify all your arresting agencies. So if you were arrested like at the Las Vegas Metro PD and the Henderson Police Department, you'll need to send a copy of the order with a request for acknowledgement to each one of those. You'll send it to the Department of Public Safety, and then they will forward it on to the FBI once they receive it. And this just makes sure all of this is to make sure that each agency complies with the order to seal and they remove all of your criminal records from their databases. Okay. All right. So this is, just more information about notifying the agency. You're gonna include the order, the notice of entry of order, and then you'll send a copy to, you'll send a copy to the district attorney. You'll send a copy to the city attorney if applicable. You'll send it to DPS. You'll send it to the court should get it, and what they will do is once they receive it and have sealed everything, they will send a letter of acknowledgement. These are some of the people that you'll want to notify. So they'll send a little letter that says, we complied with the order, blah, blah, blah. Your records have been sealed with us. Okay. Now they don't always send letters. That doesn't mean that they didn't comply, but most of them will. Like the Las Vegas city attorney never sends a letter, but they comply with the order to seal. I've never had an issue with that. Courts don't always send, so like the district court or the Las Vegas Justice Court doesn't always send a letter, but you can go online and put your name in the court website, and if nothing comes up, it's been sealed. The Department of Public Safety will send one, and that's the big one because they're the one that sends it off to the FBI. And when people do background checks, that's usually where the background checks come from, is the FBI database. So if the FBI has sealed all of your Nevada records, then when they do a background check, it's not going to show up. So that's the big one. We always look for the Department of Public Safety acknowledgement, and we'll generally close cases after that because we know that the FBI has sealed your record. After the records have been sealed, you can put no to any application questions regarding being convicted of a crime. So like on, a job application where it says, have you ever been convicted of a crime? If your records have been sealed, you can say no. A person's record will no longer be visible except to certain federal agencies. This, includes USCIS, which is the Immigration Department, ICE, the CIA, the FBI, and the Gaming and Control Board. Now, if you have a current immigration case going on, they're going to require copies of your criminal record. So if you're going to try to seal before your immigration case is done, or like you want to get naturalized or things like that, you're going to want to request a full copy of of your criminal report before it gets sealed. Otherwise, they will make you unseal it so that they can look at everything. Generally, that's only for any type of immigration, so USCIS and things like that. It does immediately restore your right to vote if that has been taken. It does not automatically restore your gun rights. And the only way to restore gun rights in Nevada is to get a pardon from the governor, which is a different process that we don't deal with. And that's it. So after it's a lot, and it does take a while, but once everything is complete, you will no longer have a criminal history. And so it gets rid of your traffic tickets. It'll get rid of any misdemeanors, any felonies, as long as they are eligible for seal. And so we do it all at once. So you'll have a clean slate to work with. So, and you can, answer honestly on applications that you've never been convicted of a crime. And so you should keep copies of because they will seal everything and you won't be able to get copies. So you'll need to make sure that you, keep a copy of the order to seal and things like that, so you have them. And that's pretty much it. And if you are a member of the Culinary and Bartenders Union, we will do all of this for you. So this was just an explanation on the process. And if you would like a copy of this PowerPoint, or you want to show this to people who are non-union, please do so. There is also a criminal record sealing class taught at UNLV. We always recommend that as a resource for people who are non-members who don't qualify for our services. But if you come to Legal Aid Center of Southern Nevada requesting a criminal record seal, we will do all of this for you for free. And so you don't have to worry about, mailing the packets and figuring out where to file, how to draft the petition, how to put everything in there. You don't have to do any of that. I or someone else on my team will do all of that for you. The only thing that will be required of you is to get your fingerprints done, to request the CHR and then the scope from each organization. And then that's pretty much it. After that, it'll be up to the attorney to use the scope and the CHR to draft the petition, check the court websites to make sure there's not any missing charges. We'll do all the mailing. We'll send everything to the DA, or we will just file it and then wait and see if there's an objection. If there's not an objection, we'll get an order. If there is an objection, we'll go with you to court. So literally, we'll do everything, the bulk of this for you for free, if you are an eligible member. So I encourage you, if you have a criminal record that you want to get rid of, to please give us a call, and we will see what we can do about getting that wiped clean for you. So it's been a pleasure. Again, if you have any questions or you just need some further information, please give us a call. Our number, the hotline number for union members, is 702-386-1550. Again, my name is Haley Box. I'm an attorney with the Legal Service Fund at Legal Aid Center of Southern Nevada. And it is a pleasure working with union members like you every day. So have a wonderful rest of your day, and be sure to give us a call if you need assistance.